Fourth. Thank you.
Howdy, representatives. Thank you for your time. My name is Pete McRoberts. I represent the American Civil Liberties Union of Iowa. We oppose House File 2082 for the simple reason that we support the Iowa Civil Rights Act as written. We were glad to see Iowa incorporate gender identity protection and sexual orientation protection into ICRA in 2007. We believe that every word of it should stay put. Here's why. Contrary to federal law, gender-based protections in the state of Iowa have to be spelled out. So you might have seen Justice Gorsuch's opinion in the case called Bostic, where federal gender identity protections are protected on account of the sex discrimination clause in Title VII. That's not the case in Iowa. In the first case, one called Somers, in 1983, the Supreme Court took a different approach, meaning if the legislature wants it, they've got to say it explicitly. 20 years later, back in Vroegh, the Supreme Court very recently said the same thing. Now, why I'm saying this is because this means that our sex discrimination statute is very limited in the state. There's no off-ramp. The sex discrimination statute does not cover things like gender stereotypes or any other protections that the feds might. So while we're very glad that the gender identity clause of ICRA protects transgender Iowans, representatives should be aware that it also protects employees from things like paying for gender stereotypes. This prevents an employee from being dismissed because he's got a high voice or because she might be taller than an employer prefers. This is why ICRA needs to stay as is. Second piece, we must also note that the U.S. Supreme Court has weighed in on this very question in a case called Vroegh versus Evans. Now here's the issue. That says that when the legislature or the Congress would pass a law deliberately, I don't want to say targeting, but referencing a specific group of people without others, that's a per se equal protection violation. Now, I'm not saying you're targeting people because I don't have to. Vroegh versus Evans also says that when a legislature grants a right that they are not constitutionally required to grant, when they remove it later, that itself is an equal protection violation. So the legislature in 07 was under no obligation to pass gender identity and sexual orientation provisions into ICRA. But removing them right now puts you on the hook for a very clear equal protection violation under OMER. Third point, I want to reference the gender dysphoria provision regarding disability. So here recently in the Fourth Circuit of the United States Court of Appeals, and then subsequently the Supreme Court denied cert. This is a case of Kincaid. Well, that court concluded that the Americans with Disabilities Act does in fact consider gender dysphoria, so a medical designation that causes distress for people, so distinct from somebody who's transgender. But the condition of dysphoria in the Fourth Circuit is considered a protected disability under the ADA. So that provision is why we're not particularly, we don't think that the dysphoria provision of this bill mitigates the harm with the bill. It just simply mirrors what the Fourth Circuit has already done and the Supreme Court didn't act on. So for these reasons, we respectfully ask you to deny advancing this bill. We believe that the Iowa Civil Rights Act does as it's intended, and we preserve every word of it and deny to advance this bill. Thank you all very much for your time.
Thank you. Is there a representative